to go to my presentation, I will maybe profit also about the question how the chambers function, just to say that when we will speak about the General Court, we have also to take into account that maybe 1/3 of cases currently, maybe more, I don't know the exact numbers, are trademark cases. So really the General Court is dealing with a lot of trademarks. And we have dealing with trademarks where it's dealt on by 3 judges in a chamber, then very often now also by a single judge, and in more cases it can go also otherwise. So if I might start with the presentation, this year I'm proposing you around 10 cases. We will see how the time goes by. The first one, the Puma case, the T159, I must say I consider it quite interesting. As you will see, all the cases which I have chosen are cases where the solution is not straightforward. So my idea was to go more or less also to absolute motives, relative motives, to see 8.1b, 8.5, so that you have an overview of what's going on the General Court, and also to show some interesting procedural issues. Maybe this Puma case is about procedural questions. And you can see the requested trademark was this blue design of maybe a Puma, maybe another feline, for different machines, processing of woods, processing aluminum. And the opposed trademarks were the black and white that you can see for clothing, boots, or footwear. 8.5 is the article which is important here, and very shortly the opposition division rejected the opposition in its entirety. In fact, regarding the reputation of the earlier mark, it took the view that for reasons of procedural economy, it was not necessary to examine the evidence which the applicant had filed in order to prove the extensive use and reputation of the mark. And what is also very important, and I highlighted, is that the examination would be carried out on the assumption that the earlier mark had enhanced distinctiveness. The Board of Appeal then on appeal dismissed the appeal. Firstly, as to the marks, it was found that there was a certain degree of visual similarity between the earlier marks and the mark applied for, and that they conveyed the same concept of a pouncing feline recalling a puma. But the Board of Appeal rejected the applicant's argument that the opposition division had confirmed that the earlier mark had reputation. Then itself, the Board of Appeal examined the evidence and it rejected the evidence as to the reputation of the earlier marks. I will come later on to the facts why it rejected that evidence. And it found that even assuming, so once more we are in the assumption of the reputation of the earlier marks, if it was a mark to be regarded as reputed, so in a theoretical fashion, the conditions under Article 5 that you see, the usual conditions, were not fulfilled in the view of the Board of Appeal. Now what happened? The applicant had 3 pleas in law in the General Court. The first one is the most important, so is the one I will read. The infringement of the principles of legal certainty and sound administration, inasmuch as the Board of Appeal rejected the evidence relating to the reputation of the earlier marks and found that their reputation had not been proved. Then the 2 other pleas, you see Article 75 and 76 and infringement of Article 8.5. So we are here in the question also of the reasoning of the grounds of the decision of the Board of Appeal. Now, it's very important we have 2 points in this Puma case. The first one is the importance of the translation of the evidence into the language of the proceedings at the EUIPO. It's in points 23, 27. In this part, the General Court took the same position as the Board of Appeal. So it was decided that if you look at the Rule 19 of the 2868/95 regulation, it is sufficiently clear to everybody to have a legal certainty about the fact that simply if you give evidence, it must be either in the language of the proceedings or it must be translated in the language of the proceedings. It is clear that we speak about evidence which is not self-evident from another language. So you can still have something in another language. If it's just about numbers, you don't need to have a translation. But here, the question was more about some market research in France and maybe some other documents. What is also important is that only some of the evidence was not translated, so still some evidence was in English, also in the current Puma administrative proceeding. And the consequence of the fact that the translation was not given was that in this proceeding, as we have seen, the Board of Appeal decided that the two interior trademarks were not to be considered as renowned. Now we come to the second point, and I think the most important in this case, because it's an application of the Agencia Vidavica case of the Court of Justice, which you all know, and which is a very important case, because you have there the principle of equality and then the principle of legality, which are always to be taken on when we or the OIPO is deciding. And very often the question is if in analyzing the facts of a case, so when we go to the legality, we simply consider it as more important than the equality part. In this Puma case, the situation was very specific. Why? In fact, as you see in point 17 of the case, then also in the point 30, for example, there is a list of evidence, including decisions of the AOIPO, 3 other decisions of the Board of Appeal, then you have around 15 decisions of national IPOs, and then you also have a ruling of the General Court with the number T66611, which dealt with the trademark Puma, and where it was always decided on that it had a reputation, or when we speak about the ruling of the General Court, it was more about design, but still mentioning the design comparable to the trademark at hand here. So the applicant mentioned all these decisions, so the decisions of the AOIPO and also those on the national level, already in the administrative instances. And the decisions of the national organs, for example, the Polish one, the Portuguese one, Spanish, and some others, contained at least references to evidence which was given at the national administrative IPOs. And then also the 3 entire decisions of the Board of Appeals mentioned that the Puma trademarks were renowned. So in such a specific situation, the General Court took the view that if the Board of Appeal wanted to go away from this administrative practice, it had either to request additional evidence, as the Rule 50 of the 2868/95 allowed, or to give reasons for a different decision on this point. It might have been possibly, for example, said that time goes by and the situation is different, that maybe Puma was reputed and well known in some anterior 10 years ago situation, but not anymore today. But that was not done in the decision of the Board of Appeal. So the General Court considered that this is a situation of application of the Agencia Vidavica case, and also what is cited is the Article 41 of the Charter and the question of giving grounds. And the General Court decided on this point otherwise as the Board of Appeal. It mentioned also that the reputation is a finding of a factual nature, which does not depend on the mark applied for. So even though the current proceeding concerned another mark applied for, the opposition was on trademarks already analyzed in other proceedings. So finding of a nature which is factual. This was also to be read together with the analysis of the Article 8.5. In fact, it was not sufficient to work with a simple assumption of reputation, as the Board of Appeal or before the division worked with. Because when you are analyzing the link or even the harm under Article 8.5, it really depends on the strength of the anterior mark. So more you have a strong mark, which is well known, stronger renowned it is, easier is it to find that there is some problem with the trademark applied for. So This is the first case. There's a second case, Nina Ricci, Romeo has a gun, is a case which might be surprising why I mentioned it in the second place. But we have here one of the situations where the Board of Appeal decision was confirmed by the General Court. I think this case, already as written in Alicante, is very interesting as to the analysis of the similarities or absence of similarities or identities of products and services. So it's really a good reading on this part. And then it's also very interesting on the 8.1b and then 8.5. 8.1b, why? We had yesterday discussions about the current status of the analysis at the General Court when it was spoken about feeble trademarks or strong trademarks. In my view, in this Romeo has a gun, the analysis is a good example of how we are working in the General Court, because maybe when you see now the trademark, at first sight, you might be surprised. Romano Ricci is relatively small if you take it all together with the Romeo has a gun, which is a little bit bigger and in this graphic element. But what was taken into account is really the whole of the situation. You are in a sector where the products are different clothings or perfumes. And it's a sector when the question who is in fact the creator of some ideas is extremely important. As you all know, it's this luxury sector. Nina Ricci is very well renowned in the sector of textile and etc. So that is why the decision here was that the part by Romano Ricci would also be taken into account in the comparison of the trademarks, because the consumer would consider that Romeo has a gun is a title or citation from an artistic work by Romano Ricci, as usual in the sector, as already mentioned. So by Romano Ricci would be considered as the mark of the house. It had a distinctive independent position, this part by Romano Ricci. And so for the services where we had identity, for example, the likelihood of confusion was confirmed. I still have to highlight that these similitudes were not considered extremely strong. No, it's just a small similarity between the trademarks because of Ricci and this by Romano Ricci, and therefore for some other products or services, no likelihood of confusion existed, and the 8.5 article was analyzed. On the 8.5 article, what is interesting is that the reputation of the Nina Ricci, which is the only one here which was with reputation in the sector of clothing, helped also for the sector of perfumery, which was one of the sectors where the protection had to be given to the requested mark. So the idea was that Nina Ricci had a reputation as a mark conveying floral, romantic, and classical concepts. So this romantic concept was found also in the requested mark. If you look at the Romano has a gun, you see these flowers all around. And the General Court confirmed the idea of the Board of Appeal that it could not be excluded, that the applicant could take unfair advantage of the reputation. And also the General Court analyzed whether a due cause existed, and it found none, at least with the evidence at hand. So neither a real coexistence on the market of marks like Francesco Ricci, neither the fact that it was alleged that Romano Ricci was a descendant in the same family as Nina Ricci, or thirdly, neither the fact that Ricci was a name in Italy. All of this was not considered sufficiently important to help the registration of the trademark. I must say one last sentence on this case. The Board of Appeal said another thing which I think was very interesting. It's not anymore necessary to speak about it in the judgment of the General Court, but also the damage to reputation was analyzed by the Board of Appeal, and it mentioned that if Nina Ricci is a romantic mark, well known for all these feminine ideas, then having a mark by Romano Ricci where Romeo has a gun is written, might somehow damage the reputation. So this idea, the concept of a gun, does not go well with the concept of Nina Ricci as a feminine trademark. So this is just to take from the Board of Appeals decision. The next case is, I suppose, also relatively interesting as to the descriptive character or absence of descriptive character, and then also to the distinctivity and absence of bad faith in the case of Neuschwanstein trademark, the T16715. It was registered in 2011, and the intervening party, the Freistaat Bayern, was the owner of the trademark for 17 categories. I will not mention all of them. I will just mention that it included some small products, some different souvenirs or articles of remembrance, and also some services like advertising agency services. The applicant, Bundesverband Souvenir, requested for the invalidity of that trademark, so under Article 52.1 on absolute grounds of invalidity, together with Article 7.1b and c. The cancellation division of the EYPO, as well as the Board of Appeal, rejected the application for invalidity, and in principle, the Board of Appeal confirmed the approach of the first instance at UIPO that the trademark was not to be considered as an indication of geographical origin and neither as an indication of any other characteristic of the products or services at hand. The Board of Appeal also considered that the trademark was distinctive, and it concluded that no bad faith was proven at the time of registration. We will see later what was the evidence given by the applicant for invalidity. The General Court confirmed the decision. Why? In fact, I will not go into all the theory which you have in the case when you look at the points where Winslow and Himse and some other case laws are mentioned, but I will just highlight that the important thing is whether you have or not a strong link between the name which might or might not be in different situations a geographical element and the products or services at hand. And so this was the main scope of the analysis in this case, because contrary to the applicant, the General Court considered that the trademark Neuschwanstein referred not to a geographical place, but to the castle which had an original, so invented name, New Swan Rock or something like that in English, invented by the king Louis II from Bavaria. And it was not sufficient to allow the public to see a sufficiently strong link to the products and services. We will see why. Firstly, the question of localization was not a question of geographical place or lieu géographique. It was really the castle, and therefore the trademark was not to be considered as a place of origin of the products or the services. It was also important, and we will see specifically in the third ground concerning the bad faith, that the castle was a museum, so it was known as such, and its primary function was the conservation of historical heritage, not the production of goods and souvenirs. The goods at hand were not produced at the castle, but only commercialized there. Even some services were not even proposed at the castle. And the castle was well known because of its architecture. It was not well known, for example, because of the products sold at. So there was no evidence to think that the trademark was indicative of the geographic provenience, and it was also not proven that it was somehow traditionally well known in that region for some specific products or services. As other museums, the Neuschwanstein castle sells souvenirs, but in fact this derives products with the aim to obtain additional finances to the functioning of the museum. And the General Court rejected the argument of the applicant that the fact that the souvenirs or other articles of remembrance make the customer remember a pleasant experience, that this should be considered as descriptive to the products. No, on the contrary, the link simply in General Court's view did not exist, and it was not a description of any characteristic of the goods at hand or of the services to remember that as tourist someone was in the castle. Therefore, it was now possible under 7.1b to say that the trademark remained distinctive, as opposing it to products and services, it was still possible to differentiate those products and services from those of other companies, and the control of quality was also something which existed or could exist in this case. As to the question that there was another decision on the national level by the Bundesgerichtshof, where the national trademark Neuschwanstein was invalidated, in point 44 of the ruling, you can see that it's not exactly decisive for the case at hand in front of the General Court. We have some other cases where still you analyze also the judgments of national courts in similar situations, so it depends of the pertinence of the aspects. If you have, for example, in Adobe case a long time ago, an English word, and you see what is said even in the United States by some court about the descriptiveness, it still is interesting, but it's not a decisive fact here. The applicant for invalidity as to the bad faith considered that the intervener, so the owner of the trademark, was in bad faith because he knew of other users of the same trademark. His aim was to prohibit such uses, and he wanted exclusive profit from the renown of the castle. So these were the three arguments on the bad faith side. The General Court noted that the evidence was not sufficient to see a bad faith situation. In chronology, it analyzed some other companies which requested a similar or identical Neuschwanstein trademark and saw that, in fact, they were not the first. And finally, the General Court highlighted the existence of a legitimate aim for the interveners, so the owner of the trademark, because, in fact, he was the owner of a castle and was acting in a way to permit visitors to profit from the museum, to make a cultural visit. So altogether, the General Court was in favor of the idea already in the Board of Appeals decision that there was no revocation. Okay. So for the 5 minutes, I will go very quickly. This case, Daisy Margareta, is interesting as to the procedural issue that if you have an application for a trademark and that application goes through the examiner for 5 products, and for 5 others, the examiner says that it's not possible to register them, then the applicant goes to the Board of Appeal. The Board of Appeal cannot reopen the whole question of all the 10 products, but is in fact competent only in respect of the 5 products where the applicant of a trademark was negatively affected by the decision of the examiner. As to the second part, as to the link, it's a question of 2 trademarks, verbal trademarks, Daisy and Margaritas, for different sweets, chocolates, and cakes. And here, the General Court annulled the decision of the Board of Appeal, as it was not considered that the link of the word marks with the products under 7.1c would be considered sufficiently strong to make it descriptive. In particular, it was not considered to be a well-known fact that the products were sold in the form of a Daisy or a Margarita. As I have just these 5 minutes, I will go quickly on the 2 cases which follows, and I will take some more time on the next one. This case, Synthesis, is interesting as a request for revocation from the point of view what is to be proved, in particular that it's important not only to show the evidence of real use of the trademark for the revocation of which a request was made by a concurrent, by a competitor, but it is also important to give a clear understanding to the Board of Appeals or the General Court of the product sector as a whole, so that it's possible to evaluate whether the proofs and evidence are sufficient. Arguments like the fact that some proofs were just demonstratives, or that the rules of the EUIPO limited the possibility to give more evidence, were not considered sufficient. This London Dry Gin is maybe another case where I wanted to show the scope of the analysis by the General Court, where you have a requested trademark, as you see it here, the Botanic Williams Humbert, and the botanicals in Spain and the botanicals in EU as anteriorities. The requested mark was for gin. The anterior trademarks were for alcohol beverages. the most important question was whether botanic would be understood by the English public as somehow descriptive to the characteristics of the gene. The answer was no, that the general public would not see that as a descriptive word, so it still is to be taken into account in the analysis of the likelihood of confusion. So the General Court took the same position of the Board of Appeal and take into account also of the identity. The likelihood of confusion was confirmed. Maybe an interesting point here is the degree of attention, where the intervener was considering the argument that if somebody is drinking gin, his degree of attention is falling down. But when you read the case, you will see that it was not really accepted by the General Court, who said that in fact the normal and usual consumer is the one who buys the first bottle and not the, I'm kind of exaggerating, but it's an interesting reading. So the last case I'd like to mention in detail, as I still have some 3 minutes, is this T566 Excalibur CTEYPO, because this is another case where we see the usual situation where anterior marks are kind of maybe weak, maybe it's a strong word to say it's weak, but you have a request for Merlin's Kinderwelt and the anterior Kinder trademarks. The requested trademarks is for different education services, different games, etc. The anterior trademark, as you know, is for chocolate pastries, but also sports and cultural services. The Board of Appeal considered that there was a likelihood of confusion because it considered the Kinderwelt was a dominant part of this complex trademark, and that the Merlin's part was not distinctive and would not be taken into account. Here, the General Court, in fact, annulled the decision mainly on the idea that Merlin's, even though in Italy, because the anterior trademarks were Italian, even though in Italy it was clear that it has some link to the legend of Arthur, as Merlin is the wizard, and everybody knows that. It's once more a term which has a clear meaning, understood by the public, but with no clear link to the services and goods at hand. So it's not descriptive, and it still has a distinctive character. Therefore, you have, in the General Court's opinion, the same normal distinctive character also for the word part Merlin and for the part Kinderwelt, which does not have any meaning to the Italian public, as well as no meaning is of the word Kinder, as it's a German word and not Italian. Therefore, in the view of the General Court, the Merlin part would be also better seen by the public because of the wizard we have here in the graphical beginning of the mark. So altogether, it was considered that the trademarks were not sufficiently similar, and the Board of Appeal altered the decision and declared the opposition unfounded. Now I have just 30 seconds, so to finish, I will not go more into details. These are just cases which you might be interested in. The T656 Perry is a case where I would highlight or underline the fact that the existence of a patent is extremely important if you are under 7EE and so if you want to analyze the functionality of a trademark, it's considered that an existence of a patent is practically irrefutable evidence that the characteristics it discloses or claims are functional. And in these two cases, Volkswagen and Globo, these are good examples if you want to see a reasoning by category, so where it was considered that the word connected word is sufficiently large that it would be descriptive to all of the products and services at hand. Same in Globo, it was a phone ringing alarm clock sound, which was considered not sufficiently distinctive because simply it was considered banal. The reasoning was given by categories. And the completely last page is maybe surprising, but I must say that we have a relatively certain amount of cases where simply the attorney drafts an application but does not have any act, any authority given to him to do it. So then it's clear inadmissibility. And I will not go into detail in the Lufthansa or some other cases. So thank you very much for your attention.